Hey friends, thanks for joining me back here in the studio on this last in this segment on arbitration. Before I start, I want to give a shout out to all of our friends, neighbors, colleagues, loved ones who are struggling through this economic downturn. You know, our neighbors, countrymen, friends, and loved ones around the world. This COVID pandemic has upended a lot of economies. A lot of people are furloughed. West Texas crude in the negative. Global economy screeching to a halt. We are thinking about all of you. We're sending positive thoughts and prayers to lift you all up. The thing that we've been talking about in this video series is arbitration, and I've talked about the difference between arbitration and mediation. And I want to talk about some more about, we've covered the pros. The pros of arbitration are, in a lot of ways, is that it's quick and that it's final, and it eliminates appellate orbit. There's no 6 years on appeal in the intermediate courts of appeals and then up at the Texas Supreme Court, or if you're in federal court, you know, it's 2 or 3 years at the Fifth Circuit Court of Appeals in New Orleans, and then, you know, petition for review at the Supreme Court, which is called a writ of certiorari, and however long that could take, and writs of requesting rehearings when the appeal doesn't go the right way. You know, the delay that can occur from appellate orbit is substantial. And, you know, you're talking like, it can be 6 years or more before the time you file your lawsuit, before you're finally allowed to start collecting on your judgment. And that's a very difficult position to be in. So arbitration eliminates a lot of that. It's fast. It's final, with the rarest of exceptions. An arbitration finding cannot be challenged on appeal. They're pretty much locked down. And if you've checked the box in an agreement to go to binding arbitration, these are the advantages of it. Here's the disadvantages, and this is where a lot of small business owners feel the pinch, and they get taken advantage by businesses that are in a stronger bargaining position. And, you know, the most clear example of that is general contractors using, in any kind of business, using with their subcontractors a non-negotiable agreement that has a binding arbitration requirement in it. And that binding arbitration agreement may just be too costly for the average Joe. For example, your average electrician cannot afford to spend, even if it's a fairly substantial electric company, they can't afford to spend $5,000 out of their cash flow just to open an arbitration claim, whereas in a state court proceeding, that costs about $400. Now, we talked about the advantage of that. That $5,000 can go and get you relief within 120 days, and it's a final non-appealable judgment, and you can start collecting your money from that general contractor. Whereas in state court, yeah, it's $400, but it might be 6 years before you start being able to collect on your judgment, and you're still going to have to pay some attorney's fees along the way. But what the arbitration fee does is it opens up the claim, and you're paying that very experienced third-party lawyer. She or he will be a 30-plus year lawyer or a 30-plus year judge, somebody with some significant legal experience, who will sit in judgment privately on your case and will conduct a final trial, a final arbitration hearing, but you'll report to a conference room instead of a courtroom. And those things can happen quick, and you can get great results. The downside about it, again, is that you know, depending on the amount of the claim, you're looking at a filing fee. Instead of in the $300 or $400 range, it's going to be in the $25,000 to $5,000 range. Once you're about 2-3 months along in the case, you're going to have another couple $1,000s, which is called the go forward fee.